Good afternoon. Thank you all for joining today. This is an OxFirst webinar in preparation of the 6th OxFirst Intellectual Property and Competition Forum, which is going to be held end of June, online June 23, 24, 25. And Meisner Bolte is one of our sponsors of the conference. So in preparation of the conference, we asked Philip Rastenbowski and Mr. Meyer, Florian Meyer, if they're interested in giving a talk on what is on their mind at the moment in the context of standard essential patents in FRAND. And I'm very happy to say they accepted, and they prepared a gigantically detailed PowerPoint presentation where I thought, oh my God, these people put a lot of work into their talk. And they'll be talking about questions relating to standard essential patents and the value chain. Philip they're both partners in Meisner Bolte, which is a law firm in Germany. They're both based in Munich. Philip is a graduate from Edinburgh University, which I'm particularly proud of because I was a scholar and lecturer in Edinburgh University in the IP law program. It's great to see graduates make good careers. I think I should pass on simply the floor to them. For those who don't know OxFirst, OxFirst is a spin-out from Oxford University. We are this year 10 years old. We're bringing economic spin to intellectual property and competition law, and we enjoy undertaking economic assessments around all aspects of IP. And it seems people are enjoying our work. If it hadn't been for lockdown, we'd have a huge party in summer, but it won't come. We'll delay our party. I'll pass on the floor now to our team in Munich, and I think you should be able to share your screen.
Not yet. We try again, but no, we still need permission.
You're not yet there and still sharing. Okay, bear with us, people. We rehearsed that yesterday and it was perfect. That's always when you're live, everybody is always more nervous. Okay, now it should work. Could you try again?
Yeah,
looks your screen. Yes.
Yeah, perfect. So thank you very much, Hoya, for having us today, giving us the opportunity to give a smaller presentation on a topic that's on our mind. We're very much looking forward to the conference, of course. So we are very interested in how it's going to turn out this year, as it was great last year. We were very fortunate last year to have this conference so shortly prior to the pandemic. And so this year we're very interested. So the talk today, we want to talk about the SEP and FRAND situation in the distribution chain, and in particular the role that implementers have, and in particular, most specifically, maybe small and medium-sized companies who are exposed to this for the first time. And so so basically our talk is structured as follows. First, we want to introduce very briefly the problems that we see that in particular small and medium-sized companies face in this changing IP landscape. We will provide a brief overview of the SEP litigation in Germany right now with the most recent decisions, provide a small introduction or brief introduction into the FRAND defense in the distribution chain, and then also discuss, in our opinion, how this whole SEP litigation will translate into the 5G environment, how this will impact traditional industries, how this will disrupt basically the way companies work and how they do IP compliance, what they need to look for. We try to provide some takeaways, some points to consider when making your IP strategy. And then, of course, we're happy to have a small or a short Q&A after our discussion. So to give a brief introduction into this whole problem area, let's say, in our opinion, for companies that have traditionally not been exposed to telecommunications sector to standards in particular, they are facing a really big challenge because the relevant IP landscape for them is changing. So we know, of course, it's, I mean, for years now, every device becomes connected. We have smart thermostats, we have smart bikes, electric bikes, we have smart cars, we have all this. And so basically what we see is that all our clients from various industries, everyone's basically producing connected devices. And so all these connected devices need to talk to each other. So most of the products in the future, in our opinion, will implement certain standards, will buy parts that provide connectivity so that sensors can communicate to each other, can communicate to host devices, etc., and can, of course, publish information to the internet maybe or other devices. And so, for example, if we have a very traditional industry and where you say, well, how is that even connected? In the stroller industry, if you sell strollers for kids, as we see on the left, nowadays we see strollers equipped with Bluetooth, Wi-Fi, to communicate with the owner, because they might be electric driven, they have electric support functions. And so also these very traditional industries require particular units that provide this connectivity option. And so also industries where we maybe 15 years ago or 10 years ago even were not thinking of that they might be in a technology driven field, they are now heavily exposed to this. And of course, this translates to the IP strategy and also the relevant IP that we have to look for. Traditionally, those companies, most of the time, they were looking for direct competitors, maybe suppliers, first tier, second tier suppliers for relevant IP rights, and then to make a risk assessment, freedom to operate, etc. And now when it comes to this SEP, standard essential patent landscape, we have new players from the telecommunication industry whose IP rights need to be followed and observed, obviously. And so these often small, medium-sized companies, they have this really huge problem how to deal with this. And so they're really before this big, huge chunk of problems, and we would like to address some of these problems today, maybe provide some guidance, what you can do to at least make a proper risk assessment and minimize risk. And for this, we are going to start with a brief overview of the regulatory framework and the case law on this topic. Philip?
Yeah, thanks, Florian. Right, to see where we are heading at, it's good to look where we are standing in the moment and where we have to start from. Just a quick wrap up. What you're seeing here is probably known to everyone in the auditorium today. It's the so-called FRAND dance, the negotiation steps of the European Court of Justice. I don't want to go into details. Just to short reminder, what was behind this idea. This is the reaction to a referral back then from the Düsseldorf court, who was not in line with then decisions of the Federal Supreme Court in Orange Book, which asked the implementer to give an unconditional offer first to the SEP owner. What most people and scholars took from this FRAND dance is basically saying, okay, the SEP owner has given a declaration vis-a-vis the standard setting organization to license everyone who's willing to take a license on FRAND terms. If that's so, then the SEP owner should ask someone who's implementing the standard, are you willing to take a license on FRAND terms? And if the implementer does not react or does not react properly, it should be the SEP owner to post the first license offer. in contrast to what the Federal Supreme Court said in the Orange Book Standard back then. The SEP owner should make the first offer because he's better suited. He knows his patents, he knows his protection of the portfolio. He can better assess the essentiality of his patents. That was the thinking behind that. Since 6 years now, courts in Europe try to get to grips with this so-called FRAND dance. Question is, what was the European Court of Justice heading at? Is this meant as a formal order of consecutive steps that have to be closely followed by the SEP owner and the implementer to avoid an abuse of market dominance, or are there maybe lines between that? And now in summer and fall last year, the German Federal Supreme Court had the first chances to interpret the negotiation steps of the European Court of Justice in the civil hire cases. As you see, it's the KZR. This is referring to the antitrust senate of the Federal Supreme Court, which is already telling. And when you read the decision, you see the Federal Supreme Court, as one point, takes a clear antitrust law approach toward FRAND. Basically, what they are saying is the SEP owner will only avoid an abuse of dominance if he offers a FRAND license on fair and non-discriminatory terms. This is for the Federal Supreme Court basically following alone from Article 102 of the Treaty of the Functioning of the European Union. That being said, the Federal Supreme Court also states that when does this FRAND defense actually work? The FRAND defense only works in a situation where the standard essential patent actually affords a dominant position on the technology market. That is, not every SEP, not every patent that is declared essential to a standard actually translates into a dominant position. Only such SEPs that are needed to offer a commercially competitive product will be dubbed essential, really essential, which will open the FRAND defense. What the Federal Supreme Court is saying here is basically, it does not matter if you give a FRAND declaration, the obligation to offer a FRAND license only follows from antitrust law. It's all in Article 102. We don't have to look whether there is a FRAND declaration given for a certain standard essential patent. If this patent is actually affording a dominant position to the SEP owner, then it's standard essential, and then only in this case the implementer may raise the FRAND defense. This is an approach which is very much differing from the approach that was taken by the High Court in the UK, which is more going on the FRAND declaration and more takes a contractual view. Just to keep that in mind, that the German jurisdiction takes a very antitrust law take on SEP and the SEP defense. So the key finding of the decisions of the Federal Supreme Court in the civil against hire case is definitely the interpretation of the declaration of willingness to take a FRAND license. The Supreme Court says it's not only that you declare, okay, I'm generally willing. No, you have to be speedy, a speedy reaction, basically within 1 to 2 months. If you find the notification of infringement from the SEP owner, you have to react as an implementer and say, yes, I'm willing to take a FRAND license. This willingness to license must be clear and unconditional. basically what the Supreme Court says is you have to basically declare that you're ready to take a license on whatever terms are in fact FRAND. This is a language that the Supreme Court takes up from the UK Supreme Court, and it gives some qualification to the willingness to license. So it's not just lip service. What the Supreme Court is meaning here, you have to walk the talk. You cannot include any reservations or include any delaying tactics. You will be held by your word to take a willingness to take a FRAND license, and you have to show this through the entire proceedings, the entire patent infringement proceedings. So your conduct of the implementer will be judged. Is he really willing? Is he really engaging in a FRAND license negotiation with the ZEP owner? This is probably the key takeaway from this decision. What the Supreme Court also clarifies is that FRAND is not static. It's a range of provisions that may or may not be non-discriminatory and fair and reasonable, that translate into a certain finding of the first offer of the SEP owner. The offer of the SEP owner does not have to be 100% FRAND. If it's FRAND, will only be decided at the end of the infringement proceedings, after the ZEP owner and the implementer have discussed and negotiated about the FRAND terms that should apply to this case. The basic thinking behind this is that the FRAND owner, the ZEP owner, will basically start somewhere here with rather high royalty rates, and the implementer will more come from down here, and it's an ongoing negotiation process where both parties have to engage in reasonable and good faith negotiations to reach at the end FRAND license terms that are agreeable to both sides. This is basically the thinking behind this new concept. Also important to keep in mind is that the German Federal Supreme Court takes or puts emphasis on the non-discrimination prong of FRAND. So everything is looked at under Article 102 of the Treaty on the European Union. This basically means there is no obligation to treat everyone the same. The question is whether is it discriminating, or can the ZEP owner justify deviations from earlier treatment, from earlier licenses? Of course, it's key for arguing FRAND if you have concluded prior licenses with regard to your ZEP or your ZEP portfolio, but you are not held to give everyone and every implementer the same set of license terms. So there is no requirement to a most favored license terms or whatsoever. If the Court of Appeal Düsseldorf in his improving handovers decision could be understood in a different way, the Supreme Court makes it clear here that this is not holding true. In the following, especially the Mannheim Court and the Munich Court applied this new interpretation of the Supreme Court of the FRAND dance in a very strict sense, and applied the high thresholds of the willingness of the implementer to the case. And it's interesting to see here that the Mannheim and the Munich Court took this necessity to really walk the talk, be sincerely willing to take a license, very put a big emphasis on this, because they looked at the behavior of the defendant, and the behavior of the defendant included referring to the FRAND defense of its suppliers and insisting on a counteroffer, which in particular the Munich court explained was so low that they must have expected that this will be rejected. So this was not considered a serious counteroffer. And from this behavior, the lower courts followed that in the end, the defendant in this case, or in these cases, were not willing to take a license after all, despite always declaring, yeah, we were willing to close a license in the end. The behavior showed to the other end in the eyes of these courts. What this brings us to in the end, as the current situation in Germany is that the onus of proof and the risk of being enjuncted from using the standard has been shifted tremendously to the implementer. If you look at this chart, which is very basic, but it tells you at least where we are heading at. If you look at this point, it's the license offer of this SEP holder. If it is FRAND, it doesn't matter what actually the implementer does, the SEP holder will always win. That is, if the SEP holder is able to manage to suggest FRAND license terms in the proceedings that are accepted by the court, he will win in the end. The only case where the claim for injunction will be rejected is probably when the SEP holder is not willing to adapt his non-FRAND license terms. So this is a currently very good situation for the SEP holder in German proceedings. So if you wrap it up for the situation, you could conclude FRAND is only looked at on an antitrust law perspective. The SEP owner can drive the discussion on what is FRAND. The implementer has a high hurdle to take the willingness prong. He has to be willing at all times and always conduct negotiations in good faith. What also helps is, of course, that different to other courts, especially to the UK courts, German courts never calculate what is actually FRAND rate. They review the FRAND terms suggested by the SEP holder, and if they believe the terms suggested by the SEP holder are within the FRAND range, then this offer cannot be dubbed unFRAND. So in the end, what's left is that the implementer has basically only the choice to accept the FRAND offer from the SEP holder to avoid an injunction. If he does not, he will be injuncted. Injunction is available at most German district courts within about 1 year from filing of suit. So this is a very comfortable situation for SEP holders in the moment. But now we have a certain a further aspect in the ongoing SEP and FRAND discussion. What is about the FRAND defense in the distribution chain? The background where this certain problem or issue evolved is the well-known campaign of Nokia versus Daimler in Germany. I think most listeners are knowing the facts of the case. So I will skip this shortly. Important to know is probably what was behind that. So the OEM manufacturer, in this case, it was Daimler making the cars, was offered a have-made license by Nokia. So only at the final step in the value chain, a license was offered. Have-made, that is, it also protects the tier 1 supplier of the telematic control unit, which is basically the infringing embodiment, the unit in the car that provides the connectivity in the car for basically everyone, wireless access, RF access, and so on and so forth. But the upstream chain also included and made use of the standard and of accordingly also of the standard essential patents that Nokia was asserting against Daimler. So this was also the smaller units, including in the telematic units, and finally in tier 3 supplier, the baseband chips for these units. But Nokia only offered a license here and a derived license to the tier 1 supplier. Nokia said, well, basically it's a principle of patent law that I'm free to select the infringer in the chain wherever I think is best to license. FRAND declaration, of course, Nokia has given FRAND declarations for their ZEPs, but in the eyes of Nokia, FRAND declaration does not mean more than the ZEP holder has to grant access to the technology to some extent on fair and non-discriminatory terms. This access to the standard would be also achieved with giving a have-made license to the OEM and end product manufacturer, which would provide sufficient coverage also for the tier 1 provider of the TUC. A further important point that Nokia made was, of course, when we look at the patent, the real value of the patent or the patented invention unfolds only on the OEM level. That is, this is the point where we have to charge our license fees, and this is where we can calculate a reasonable royalty best. And finally, Nokia basically said, this license at end product level is what we always did in this environment in the SEP and telecoms field. And Article 102 of the treaty would not prevent from the SEP owner to design and tailor their license model as they see fit and best. This, of course, leads to some specific problems, especially as regards exhaustion of rights, because unlike the US, in Europe, we have the concept of European-wide exhaustion. That is, only when the product is brought on the market in Germany first, or in a European member state first, this product unit will be exhausted with regard to the patent rights. Also, what does not exhaust are process claims in the patent. So process claims can always be asserted on the side if it's not provided in the license that they shall also be usable for the licensee. This kind of issue basically brought the German cartel office into the game. They sent amicus curiae briefs and asked all district courts where the 10 infringement cases from Nokia were pending to stay the case and refer this question to the European Court of Justice and ask them if that's correct, that if the supplier is also asking for a license, if you deny this license, is this correct or is this an abusive conduct? Because what had happened, the tier 1 supplier and the tier 2 supplier, in this case, the tier 1 supplier was under inter alia, it was Continental, tier 2 supplier inter alia, it was Huawei. They gave their own declaration of willingness to take a full and unlimited license to the ZEP portfolio to Nokia. What Nokia did was in the end to say, no, we will not license you, we will only license the end manufacturer. So Nokia was offering access to the technology, but at the level of the supply chain where they choose and believed to be best approach. to implement that. While the Mannheim court and the Munich court followed Nokia in its arguing, the District Court of Düsseldorf did not. They stayed the case and referred questions to the European Court of Justice. Basic argument is, if you give a FRAND declaration to the standard setting organization, you are under antitrust law obliged to grant unlimited access to the standardized technology. And this is true for every stage of the value chain. So the Düsseldorf court basically said that only giving a license limited to the car industry would not comply with the FRAND commitment that Nokia had given. Also, FRAND commitment would mean, in the eyes of the Düsseldorf court, that the license terms that are offered would provide for full exhaustion of rights, including exhaustion of process claims and exhaustion for every sort of use of the patents, without a limitation in regions. So this was intended to get around this limitation by the EU-wide exhaustion principle we currently have. So in the end, the Düsseldorf court considered Nokia's approach to only license the end product manufacturer to be not in line with the antitrust provisions in the EU. What they said is that the have-made license to the end product producer would limit the supplier's commercial freedom to get a full license and really exploit the standardized technology, not only for making cars or making parts for cars, but for every potential field of application of this technology beyond the car and automotive sector. Also, what Düsseldorf is saying is that licensing at the supplier level would be very much in compliance with the commercial practices in the car industries, where usually the suppliers are closer to the technology they are selling than the car manufacturer itself. The car manufacturer just takes all the pieces, bits and pieces, and puts it together to a car. But as Daimler always emphasized, for them, this TCU is only a black box. They don't actually know what they're doing. But the tier one and especially tier two suppliers, in this case Huawei, of course, they are in the field of technology of Nokia. They know what 2G, 3G, and 4G essential patents would mean. So the Düsseldorf court says it would be more compliant to ask these entities and address them with a license. Also, with regard to Nokia's license scheme and license model to only license the end component manufacturer would have no relevant benefits for the consumer welfare. This, again, is a very antitrust law argument. If you cannot show why your limitation on competition brings extra benefits for the overall market, then you're more likely to be found to abuse your market power. So in the end, the Düsseldorf court found the conduct by Nokia to offer Daimler an end product license, but at the same time denying a full license to the supplier as arbitrary and discriminatory conduct under Article 102 of the European Treaty. And this is why the Düsseldorf court stayed the case and referred the questions to the European Court of Justice. So these are basically the questions that the court has raised. I don't want to go into more detail, but it's basically, as just said, is the patentee obliged under Article 102 to license the willing component supplier? Again, it must be observed that the suppliers, Huawei and Continental, gave their own declaration of taking a full license. So they were willing. The question is, does Nokia or any SEP holder is obliged to offer them a full license as well when they are willing? As said, the Düsseldorf court explained this is basically the full meaning of the FRAND declaration given by the SEP holder vis-à-vis the standard setting organization. Also, the Düsseldorf court raised this question, is this not particularly the case if the licensing of the supplier is customary in the concerned market? It's probably the case that Düsseldorf court found a lot of references in the Huawei ZTE decision of the European Court of Justice that always referred to the commercial practice that should be observed in negotiating FRAND license terms. And of course, this was also a very important point for the Düsseldorf court. Does FRAND in the end mean that you have to offer a set of terms and rates that basically provide full exhaustion of rights within the supply chain? So if you license the top of the supply chain, you basically have to offer a license that provides for full exhaustions downstream of the full chain. So this, of course, raises one open question, which before has never been properly addressed by German courts in detail, is the calculating of the correct license fee. As I said earlier, German courts don't toil with calculating FRAND royalties, but here we now would have the question: if under European and German antitrust law, the SEP holder is obliged to license, let's say, the tier 3 supplier, the top supplier in the supply chain, with a license that leads to exhaustion for the downstream supply chain. What is the value that should be these FRAND rates and royalties should be based on? The Düsseldorf court says, and is in agreement with Mannheim and Munich, it must in the end be the value of the invention for the end product. It would not be correct to calculate based just on the component price. That would be too low. But if you license the top level of the supply chain, it will be difficult to ascertain what is actually the value of the invention for the end product, taking into account that the FRAND license, in the view of the Düsseldorf court, shall not be limited to certain sectors, let's say the car sector, but should be such that the technology could be exploited in every field of technology anywhere in the world. So this will be a next upcoming topic in our eyes, how you then, if the Düsseldorf court is right, if you then calculate FRAND license rates. So how will this current situation of SEP litigation and the status we currently have translate to the 5G environment? And for this, I will give back to my colleague.
Yeah, thank you. So based on this legal background, so the question is, what happens in the 5G sector? Maybe we're using 5G more as an umbrella term for IoT as well, or Industry 4.0. And so maybe we can learn something from the smartphone wars that we had, but there are some characteristics of these smartphone wars, basically. And one important thing to consider is that back in the day when we had these smartphone wars, the SEP owners and implementers, they were often actually in the same field of technology. There were maybe different handset manufacturers. They usually were on the one hand implementers, and on the other hand also SEP owners, and they're very well familiar with all these standards because they were working on them as well. So there was a high symmetry of information, and so basically it was a fight among equals, maybe, if you want to say that. And so in contrast to that, and in our opinion at least, the characteristics of the disputes to come, when we have the traditional industries facing SEP owners coming from the telco sector, the technology underlying this is extremely diverse. As stating initially, maybe we have the children's stroller industry, and then we have the bike industry, and they're all becoming connected. We have so many different technologies and industries using these connected devices, and so it's extremely diverse. The 5G standard in particular is huge, hardly manageable. The number of patent applications is insane. The standard itself is not one standard, but it's basically modular and has many different components, and you really need to know what you're doing when you say, well, I use 5G, but you really have to know what this actually means. And of course, there's then a huge asymmetry of information. As a small, or not small, but an SME, a traditional industry, they want to negotiate one license. But of course, the SEP owners from the telecommunication sector, they have negotiated maybe hundreds of those license terms before, and they basically know what they're doing there. And so there is a high asymmetry of information, and also a high asymmetry of bargaining power, obviously, because the SEP owner potentially has a dominant position, as the implementer needs to basically obtain this license. And so if we put that into some other numbers, maybe if we look at who's leading the 5G patent race, we have the well-known players from the telecommunications sector, but the impact will be on so many various industries. Obviously, automotive, probably they are now also maybe up to speed on that topic, so there's not so much of asymmetry there anymore. Cloud services, but manufacturing, a huge field where we have a lot of specialized companies, maybe manufacturing filters, presses in certain areas. So it's so diverse, and these companies they sometimes even don't have their own IP department. Maybe they have an in-house counsel, basically. And so if we look at the problem, it's maybe something like David against Goliath. And so the question is, what can you do when you're an implementer, when you're a small, medium-sized company? One problem being, of course, what do I do with this huge number of patents that are declared essential? How can I check whether they are essential? Do I have to do it? We just wanted to refer that there's a survey or a research paper out from the EU Commission from last year, where they tried to evaluate the number of essential declared patents that are actually essential. And basically the conclusion is it's impossible to just simply come up with a number. The topic is so diverse, it so heavily depends on what kind of features you're implementing in the certain standards. Sometimes it might be essential, sometimes not, etc. So it's too complicated, basically. But our goal is, of course, to provide at least some guidance of what you can do, and to show that the implementer is not basically without any means what to do. And so from our perspective, at least, what is really important is that the implementers or the traditional industries, they come into the driver's seat. They're really actively pursuing their own IP strategy, and they're not just waiting what will happen to them if there is ever a SEP holder approaching them. And so there are a couple of things you can do. One important aspect, even though it's difficult, agreeable, but you need to conduct a detailed SEP due diligence. So in our opinion, this means make a product to technology mapping, technology to standard mapping, so you know what standards you're actually using. And then you need to identify licensing opportunities, meaning identifying, for example, patent pools that provide licenses on this level, and also maybe other companies that are willing licensees. They want to talk and try to obtain, of course, respective licenses if that makes economic sense, but of course you should. And then it's in the end, it's a risk assessment. And so in our opinion, IP due diligence really becomes a compliance issue in this case, because there is no per se freedom to operate potentially, because the number of SEPS is just too big. You probably cannot cover an entire standard with licenses on practical terms, but you need to make a risk assessment and see what needs to be done. And there you need to, of course, minimize the risk or your exposure. Another thing you need to do is, in our opinion, in particular in the distribution and the purchasing chain and value chain, is to revise the purchasing strategy. Because of course, we all know regular contracts, they have this clause, anything that's sold is guaranteed to be free of any third-party rights. But for the OEM, for the end manufacturer, for the entity selling the product in the market, the question is, does it help me in practice? Because it might be legally sound, but on the other hand, of course, the SEP owner, as we heard previously from Philip, will approach the last entity in the value chain, and there is an injunction in the room, basically. And so it might not help from the business perspective that I have this clause if I have my injunction, and then I can maybe get some damages back from my suppliers. But in the end, that is not, on practical terms, it's not enough. So in our opinion, what needs to be done is, in the purchasing strategy, you really need to include license coverage requirements in your RFQs, your request for quotes from your suppliers, and also include obligations to provide product-free and third-party rights or obtain a sufficient license coverage. So it's you can make it a requirement for the supplier to at least try to obtain these licenses. Of course, it should also be the case that covenant needs to be included to mutual support and FRAND negotiations and litigation, including allocation of risk, cost of license, cost of litigation. This should be already put into the contracts so that you don't have to talk and discuss about this at a later stage when it might be a bit late for that, essentially.
And when talking about taking a proactive approach, of course, it's always nice to be prepared, and you must be prepared. You have to take this as a new IP compliance challenge, what's coming at you as a producing company. That is crystal clear. But this may maybe in the end not be enough when you're confronted with a claim and patent infringement suit by the SEP holder. So what can you do? In the moment, it shows there are not so many options. We see the battle, these side battles of anti-suit injunctions and anti-suit injunctions, which in the end have basically no effect, as we see. What else is there that you could do to get back in the driver's seat, also as a manufacturer and as a supplier? And one option that we believe will be seen more often in the future is an active approach, claims of the manufacturer, or more likely of their suppliers, to actively ask SEP holders for a license, a FRAND license to the portfolio, not limited to a certain industry, but a free license on the top of the license chain. Then, should the opinion of the Düsseldorf court hold true, that a FRAND declaration of the SEP holder basically means that the SEP holder is obliged to license at every level of the license chain and provide FRAND license terms that in the end provide for worldwide and full exhaustion of the patent rights, then anyone in the supply chain could make this claim either under antitrust law or even based on Article 6 of the ETSI rules or the comparable rules of other standard setting organizations. Where would I bring such a claim? You could, of course, think about a counterclaim if you are already attacked by a SEP owner in a patent infringement claim, but you also could bring it proactively. At the seat of the SEP holder would be the closest thing. So preferred battlegrounds would then in the end, European countries maybe, but more likely the US and even China, where a lot of suppliers are sitting for the technology field. But you could also bring such a claim wherever the competition of the market is limited and restricted by the conduct of the SEP holder. So this basically would open up jurisdiction in every European member state where the SEP holder is asserting its patent. The other question would then be, how do I draft this claim? What can I reasonably request? There is a discussion ongoing, but it will be more unfolding in the future. Is either you ask the SEP holder to offer FRAND license terms. So the SEP holder would be in the position and under the obligation to disclose his prior license terms and argue why he believes these terms are FRAND. And in the end, I could leave it to the court to correct the SEP holder's terms as being excessive. This is basically the old approach brought by the Orange Book Standard jurisdiction in Germany. So have in the end the court decide what is FRAND, or if you follow the rule that FRAND is a range, you have basically a FRAND corridor where very high rates may be FRAND, but also very low rates may still be FRAND. Then it would be a good chance for the supplier to suggest its own FRAND rates based on his own idea of what he believes is a reasonable FRAND rate. So no one before said in the end a FRAND license only on the component level would be unFRAND. Might be not reasonable or not directly acceptable to the FRAND owner, but it doesn't say that a component level license or a license on a smallest sellable unit is in the act unFRAND. So if you bring as a supplier your own case for a FRAND clause, you are in the driver's seat to offer FRAND terms and thereby turn the tables around. And there are some cases pending, one in the US, Apple versus Qualcomm. There's one case, this is in the UK, Apple versus Qualcomm. In January, Continental filed a suit in the same direction against Nokia. And we are of the opinion that this is a measure that will probably is likely to be more used in the future in this field to cut through the 5G patent thicket and provide more security for suppliers and the manufacturing industry alike. So wrapping this all up, as said, we are of the opinion that in light of the 5G revolution, every portion, every industry will be touched by this topic. So everyone should seek to take an active approach. Producers and suppliers need to have revised purchase strategy that takes the aspects of SEP licensing into account. You need to have a proper risk management. And in the end, it will be an option, and we are likely, we believe that will be a likely scenario that suppliers will more actively advance SEP holders to ask actively for FRAND licenses.
So yeah, that was our not introduction, but our talk on this topic, and we are happy to receive any questions you have, any discussions. Please let us know.
That's amazing. I learned a lot. Thank you very much. Thank you very much for your talk. I learned a lot by listening to you. My personal take is there will be at some point a need for economists in Germany in the IP space. If a massive decision is being taken on the grounds that one party makes a statement about the value of the standard essential patents, and the other party makes a counter statement, which the court then considers to be too low, the inherent bias of the argument is that that statement from the first party was adequately calculated. And if that isn't assessed, I'm very concerned about justice. I have the sense to be just, to be fair, to pay full respect to the German judicial system, which really has a strong reputation. There will be some sort of need to introduce economic reasoning in the system, just to really make sure that if you make such a massively strong statement of what is a willing or an unwilling licensee, you really get the economics right. That was one of my takeaways from what you said. But I also thought that your comment and your idea of starting a risk due diligence could be quite helpful for many SMEs who may not even understand at the moment that they may have an issue on their toes. So I think that could be one way maybe to help balance the system, or to help understand how to take it forward within the context of 5G. There are a few questions. Okay, one is from Peter Koch. I'll read it out. Is it really feasible to ask your supplier to ensure that the products are free of third-party rights? Will that blanket statement remove all risks of you? Wouldn't you still have a duty of examination and may not rely, for example, on information provided by the supplier? What is your advice for the supplier? How can the supplier mitigate the risk of having missed the standard essential patent?
Yeah, it's a good question.
Thank you. I think this is a question we could do another webinar on. There are many questions upon. Of course, this is all not straightforward, and you always have to look at what is actually feasible in practice. You have to look at the company, at the end manufacturer, which bargaining power has he. I mean, we are now talking about the so-called car wars, where you have Daimler, one of the biggest car manufacturers in the world. Of course, they have big bargaining power, and they, of course, can draft different sourcing agreements than smaller SME companies. What is also clear, you will never get out of the problem that you as an end manufacturer putting the product on the market will be infringing in the patent law sense. So you cannot mitigate the risk. Your option would be to shift this risk as best possible to your supplier. And if that's not feasible, the alternative is only stay away from this supplier, but look for a supplier who is not fully licensed, but who has already a good set of license in hand that he can offer. This may not be the cheapest offer for you, but it would provide for more security. We couldn't discuss now any single case by case what to do in a certain environment or in a certain scenario. It's just, I think the issue currently in the industry is that most people are unaware what's coming there. Everybody's talking about IoT, everybody's talking about 5G, but only few people know what this in the end means from a patent and competition law perspective. So I think a lot of is gained if more awareness is reached in these kind of fields of technology. And I think the Düsseldorf court is taking a very competition-friendly approach there for mid-sized companies, and it's laudable that they brought this back on the table to the European Court of Justice. Of course, this will delay things. We will have to wait for 2 years' time till we have a decision, and we will have to see what this in the end brings. But highlighting this problem by the Düsseldorf court and not basically going over it like the Mannheim and Munich court did in a very strict, very harsh sense is probably the most laudable bit on the Düsseldorf court's referral to the court.
Yeah, and maybe just one minor thing to add. I just had a discussion with a client 3 weeks ago, I think, that asked us. It was a supplier for the smartphone industry, and they were supplying smartphone end device manufacturers. And so they asked us, like, how can I sign this? And they were worried to sign this blank check, basically say, well, everything's free of any third-party rights. And they said, well, how can I do this? And then we really sat together and made some risk scenarios, basically, to try to come up with something that helps them to mitigate that risk. But of course, it's difficult.
The future lies in risk scenarios, in just really starting from the outset, trying to manage risk and trying to involve all means before any trouble arises. There are a few other questions. There's one question which says, if you're a telecom operator, say Deutsche Telekom, who owns network infrastructures, what should you be worried about here?
I think they're already worried about many things. But I mean, for them, they are really, in most cases, they're buying most of the parts from large suppliers that are very active in this field already. So, for example, Deutsche Telekom might buy from Huawei or Ericsson, or I don't know, Nokia, maybe even. So from players that are really active in this field. And so these companies might have, they might have good license coverage to some extent, but of course, it's for them, again, it's a risk scenario, and it depends on basically on what you're looking at. Are you looking at a single function that's within the standard, or are you looking for the entire standard, basically? So there, I think the conversation is very complicated because the technology is very complex in that case.
And of course, you have to also do a due diligence of your supplier. Of course, companies like Huawei or Nokia or Ericsson might be better placed than others in the moment, and they have a good coverage of the portfolio and of the standard, but there still may be gaps, and there may be gaps in the license agreements that were concluded before. Because as the Düsseldorf court highlighted, the issue is the exhaustion term. Do I have a partition of the markets? Can I sell the product anywhere in the world? Or do I have to pay higher license when I bring it to Europe or to the US? And what's with the process claims? This is the biggest issue. Most of SEPS in the telecommunication field rely on process claims, which you cannot exhaust automatically under patent law. You have to have a license or a sub-license to use the process. And this is also a point that you have to really closely look at what is actually licensed. Of course, when your supplier say, I have a license, you have to look in the license and see what is the actual coverage coming out of it and what are the limitations. And in the end, it's probably, and this is something that the car industry is probably understanding right now as well. You cannot just say, okay, you provide the product free of third parties' rights, and then in the end, I have claims against you when there's an issue. That will not solve the problem. Parties will have to come to a point where they share issues, risks, and costs probably. That if the value of the license is decided on the value of the invention for the end product, but the supplier has to pay the royalty, then you basically have to share this royalty. Otherwise, you have a connectivity box that has a value of $5, but the value of the invention for the end product, that might be a car, that might be a smart home, smart device, is like $30. That will not work in the end. So there must be some solution for the shared risk, and people should be aware of this.
I think we have gone over time. It was really interesting to learn from you. Is there any last comments you'd like to make, or any key takeaway? I mean, my takeaway is risk assessment is important. Any other
I think that's
message?
the message we wanted to convey today. Really, just look at what you're doing, be aware of what you're doing, and make a proper risk assessment. And yeah.
Yeah, no, thank you, Philip. Thank you, both of you. Very, very interesting. I learned a lot. We have still kept a few of our participants until the bitter end. This is encouraging. Yeah, if you have any questions about the presentation, we'll email it to everyone. Let us know. Otherwise, if you want to get involved in the OxFirst IPN competition forum 6th time, end of June, not end of January, end of June online, let us know as well. And thank you very, very much for listening in. Yeah, we'll be in touch, and yeah, we'll have other events too. Thank you again. And big thank you to both of you, to Munich, for spending so much time on preparing an excellent presentation at great length. Thank you.
Thank you.
Thanks. Oh, yeah. Have a good day. Thanks for having us. Thanks for listening.
Bye-bye.
Bye-bye.